In this lesson, we'll define what a security is and is not. We'll look at securities that are exempt from registration and a couple of transactions that lead to the same end. The securities that do have to be registered with the state, there are three methods. We'll look at that. And whether something is registered or not, we'll remember that it's subject to the anti-fraud statute. There can be nothing misleading about the offer of securities. And finally, what is an issuer of a security? It's a very simple definition. It's not always easy to determine if something meets the definition of a security, and why does it need to? Why would we care? The state securities department has a problem with investors losing money, and before they can do anything, they have to establish that what was offered and or sold does meet the definition of a security. Now, if it's a note, like a promissory note or a stock or a bond, obviously it is a security. But maybe the promoter didn't think of it that way, and he used a different term altogether. It really doesn't matter what term was used. Under the Supreme Court's Howey decision, Howey decision, the investment contract was already listed in federal and state law as a security, but no one knew exactly what that meant. Well, after this case, and when the decision came out, we say that if it's an investment of money in a common enterprise where the investors are going to only profit through the efforts of others, then no matter what it was referred to, it meets the definition of a security. The most practical application of this would really be for business owners. And I think a lot of them are offering securities without realizing it. If they looked at their paperwork, the state would say, don't offer any interest in this S Corp or LLC unless it complies with the Illinois or the Ohio Securities Act of whatever. A lot of people probably just blow that off as fine print, but if it's an LLC and the owners who are managing members offer 10% to one of their key employees, if he's a non-managing member, then he's expecting to profit through the efforts of others, and this transaction that's taking place is subject to full disclosure. Maybe his mom is an attorney and one of her partners specializes in securities law. If somebody loses money subject to this, you could end up being sued as an LLC or an S Corp, etc. So this doesn't just come into play for public companies. Anybody who's offering a security should really consult with an expert. Do I need to register this? If so, how? How does that work? And all that good stuff. And they might be able to figure it out from the website. But if it is a security, it is subject to full disclosure. And if you're offering the security to any person, you have to make sure that you don't leave out important facts. Fixed annuities, whole life insurance, these are regulated by the insurance commissioner. So if it's a pure insurance product, it's not a security. But there aren't many examples of things that are not securities. What about variable annuities or variable life insurance? Those are both insurance products and securities, which is why agents who sell those products need life and health and also a particular securities license. Some securities don't have to be registered. There's really no logic or easy statement as to why, and watch out for that. Some of our trick questions will say, well, an exempt security is really just a security that's much safer than others. No, there are insurance companies who issue stocks and bonds that you would wish you never bought. Same with banks. Many banks go belly up. There are religious organizations that are just barely making it. If you buy bonds issued by them, it might be one of the riskiest investments of all. You're going to, as an investor, receive offering documents, but the government or the religious organization that issues the security, they do not have to file a registration statement. What if we're a company who wants to take on some investors, but we don't want our competitors in the whole world to know all the details of our business? There are two exemptions available there, but they're based on the transaction, not the security. So here the security, for whatever reason, is excused from having to register. Here, the security wouldn't be. You're just a small private S Corp or LLC, for example. You could be a C Corp and still be private. But if you're only going to offer to up to 10 individuals who reside in the state, you can just provide those individuals with your full disclosure. You don't have to provide it to the state who's going to make it a public document. You can keep it private. But only offer to 10, not offer to $1 million and then settle on the final 10. No, we can only approach 10 people. So right there, it sounds more like you're forming a small company. You probably know these people very well. They're friends and family usually. Or they're professional institutional investors like venture capital. We're the company, we're going to sell up to 40% of our stock to this venture capital firm. We're going to provide them with full disclosure, but neither they nor we want the whole world to know our business. So they're going to sign a non-disclosure agreement. We're not going to do a complete registration statement. It's just that after the offer is completed, we'll notify the administrator that it happened, and we'll just give the most basic facts. What industry, where are we located, how much did we raise, and nothing that a competitor couldn't find out from our website. Pretty much. All right, so these are securities. The people who are offering and selling them are still subject to full disclosure. Don't do anything manipulative. It's just that no registration statement is going to be filed with the administrator. With the exempt transactions, it's just a notice and very scaled down after the fact too. Now the middle way, filing or method, it was not used that often. But as you can see, if you were doing an additional offer, you're registering with the SEC, you were really just filing some documents with the state, and you were automatically good to go when the SEC said so. Let's look at the two more important methods. If you're going to offer your company's stock in at least 2 states, and it would probably be all 50, but either the stock won't trade, or it's only going to trade on the over-the-counter bulletin board, for example, not NASDAQ, then you would get no exemption at the state level. But you're really dealing with the SEC here. You're going to register with the SEC, and then whatever important documents you file with the SEC that the states want, you give them copies as well. You pay your fee in the states. And then when the SEC gives you the effective release date, then you can complete the transaction, the IPO. So small company offering. Or the company, again, they might have securities that aren't going to trade anywhere, or we're really just going to offer to investors in our state. Then under registration by qualification, we don't register with the SEC, we only register with our own state securities administrator. And then we have to wait, in that case, for the securities administrator to give us the effective date when we can actually take the money and complete the transaction. So watch out for any blanket statements. Some securities are registered with the SEC and the states. That would be coordination. Some are registered only with the SEC. That's federal covered. They don't deal with the states, obviously. And then there's qualification where it's only offered, it's only offered within the state and registered with the state, not the SEC. So again, federal covered. It has an exemption at the state level because it will register with the SEC, and it trades on an exchange where the exchange regulates the companies who have stock trading there. If they don't meet all these rigid requirements, they'll be delisted, or they'll have a little E or something added to their symbol, and everyone will know there's something up. Whereas if a company has stock trading on the over-the-counter bulletin board, that doesn't mean they've met any sort of milestone at all. But a federal covered security trades on NYSE or NASDAQ. These are listed securities. They tell the whole world their business, but only through the SEC. And therefore the states don't need to worry about it. All investors of their state have access through the SEC's website, etc. The common stock of those companies is federal covered, and then senior securities means also their preferred stock and their bonds. Investment company shares, so the Bond Fund of America or the Growth Fund of America, etc., they're not registering with the states, but unlike companies whose stock trades on an exchange, they do have to do a notice filing. How many shares were sold in my state? Because open-end funds are in a continuous state of offer. And during the offering period is when the state gets very concerned. If your stock trades on an exchange, it's subject to all those rules. And whether this offer has to be registered or not, if we're offering to that venture capital firm or those 10 individuals, yes, you're doing an exempt transaction. But any person who's connected to the offer, sale, or purchase of any security has to make sure that they provide full disclosure of all important facts, they don't mislead any facts, and they certainly better not show any sort of false reports, PowerPoint, here's a prototype that's in development stage when it's really just, something that a prop department could come up with. I've seen companies in the Chicago area that had investors come into a factory tour, and to assure them they had their employees sending boxes down the assembly line. Turned out later the boxes were all empty. I don't know if that's a device or a scheme. I think that's a scheme to defraud. But in any case, that company probably got sued by those investors. A security is obviously issued in almost all cases. We don't want to get into the minutia of the Uniform Securities Act. But if it's Starbucks common stock, Starbucks is the issuer of that stock. If it's a U.S. Treasury note, the United States Treasury is the issuer. So it could be a government, it could be an individual, it could be an estate, whatever. Any person who issues or even proposes to issue any security, it could be exempt or not, that we only get concerned about that if we're talking about registration. You are the issuer of the security if you are the one on whose behalf it's being issued, or you got your name on the stock or the bond. But again, person could be trust, individual, a company, etc. So if it's a security, it is subject to anti-fraud, and that's why we often use the Howey case. We don't need to debate if it's called a promissory note. A note is the first example of a security. Some securities are excused from registration, some because the transaction makes it exempt. If the security must be registered, it could be done through coordination. If it's offered in many states, that's how it'll usually be done. Or if it's only offered in one state, it'll be done under qualification with that administrator. And regardless of registration or not, the people who are connected to the offer of this security need to provide full disclosure and not do anything misleading. And again, the issuer is just any person who issues or proposes to issue any security.